It's a pleasure for me now to introduce my colleague Eric Goldman, who is a member of our faculty and will serve as a moderator of the first panel. He'll introduce our panelists and tell you a little bit about that topic. Thank you. Enjoy the day. Eric?
Yeah, thank you, Dean Polden, and thank you to all of you for joining us today. I think it's so exciting when we're able to create these types of spaces for us to engage in a dialogue on important topics, and I think the work of the students today in preparing this event really allows us to benefit from that. As Dean Polden said, my name is Eric Goldman. I'm going to act as the moderator for the first panel this morning. I'm an assistant professor of law here at Santa Clara University. I'm also the academic director of the High Tech Law Institute. And today we're going to talk a little bit about the ways that technology can regulate people's behavior, both online, although in some cases we'll also talk about offline as well. And in particular, we'll focus on technological protection measures, technology that can control what people are doing. And we're very lucky to have 5 experts on this topic aid us in the inquiry. We're going to have roughly 10-minute presentations from each of our 5 speakers, and then we're going to turn it over to some questions and dialogue among all of us. The first speaker today is going to be Dan Burk. He's a professor at the University of Minnesota Law School. He's an expert in intellectual property and cyber law topics, among other claims to fame. He's written one of the leading law review articles on DRM, digital rights management regulations. After him, we were going to hear William Coates Smith, who was listed on some of the collateral for this program. Unfortunately, he had a death in the family and was not able to join us, but we're really lucky to have Chelse Ferrero join us in his place. She's an attorney at the Palo Alto office of White & Case. She represents entertainment interests, including, most specifically for purposes today, the DVD Copy Control Association and their lawsuit against Kaleidoscape. She's also an alumna of this law school. After that, we're going to have Paul Bawel. Did I say that right? Bawel. Pronounce it. I apologize. Join us. Paul is a senior intellectual property attorney at Microsoft Corporation. Among the things he works on for Microsoft are providing legal support for Microsoft's media products, most specifically some that have digital rights management technology incorporated into them. After that, we're going to have Dr. Michael Geist join us. He's a law professor from the University of Ottawa. He is one of Canada's leading intellectual property and cyber law experts. And in particular, one of the things that he's done among his many, many claims to fame is that he's been one of the leading commentators on Canada's consideration of anti-circumvention legislation. He created a wiki called 30 Days of DRM, where he led Canada's discussion about some policy aspects of enacting anti-circumvention law. And our last panelist will be Mark Lyon. He's a third-year law student at Mississippi College School of Law. Among other things that he's done, he is the webmaster of SonySuit.com, and he was a plaintiff in Lyon versus Sony BMG. With that, I'm going to turn the panel over to Dan to open up the remarks.
Thank you, Eric. I'm very pleased to be here and to have a chance to participate in the discussion today. While I hopefully find my PowerPoint slides here, I'm going to try and draw some parallels, look for some commonalities among some different areas of intellectual property law, including the Sony DRM situation that we're going to hear more about in a few minutes. These thoughts and comments grow out of some discussions that one of our organizers, Adam Marcus, had with me while we were both at the Max Planck Institute for Intellectual Property Studies in Germany last summer. So it seemed appropriate to present them here. And I'm couching this in terms of intellectual property responsibilities. We often talk about intellectual property rights. I'm going to suggest by the end of this little sketch that I'm going to offer to you that perhaps we need to think in terms of intellectual property responsibilities as well. And I draw some of that from Michael Geist's colleague Jeremy De Beers, who's written about that in Canada. So So we start actually with a Canadian situation, a Canadian case, Monsanto versus Schmeiser. You may wonder why we're thinking about that when we're supposedly talking about DRM, but I hope that'll become clear in a moment. You may have heard about Mr. Schmeiser. He is a canola farmer in Canada who was found to be growing Monsanto patented Roundup-ready canola plants on his property. This is a genetically modified plant that is designed to resist the Roundup herbicide, so you can grow this type of plant and then spray your fields with Roundup, and it will kill everything except the plant that you are hoping to grow. Showed up on Mr. Schmeiser's property. He did not have a license to be using this patented invention. Typically, the seeds for this actually come with a bag tag, or what I've called a seed wrap license, almost like a shrink wrap type of license on the bag. But he didn't have such a license and was perhaps making, perhaps using, certainly selling the claimed invention without a license. And he said without his knowledge. Mr. Schmeiser says he had no idea how those plants got onto his property. Now, it was fairly clear that the trial court in the case, this has been all the way up to the Canadian Supreme Court, trial court in the case didn't believe that, but sort of adopting a motion to dismiss or summary judgment type of standard, viewing the facts in the light most favorable to Mr. Schmeiser, the facts are quite interesting because it's entirely possible that you could have this invention growing on your property without your knowledge. Mr. Schmeiser says perhaps some seeds blew onto his property, or even more likely, perhaps some pollen from one of his neighbors who was growing this genetically modified plant, blew downwind, fertilized his plants in a previous year, and when he saved the seeds to the next year, he ended up with plants that had the claimed invention incorporated into the seeds. And in fact, he said that damaged him because he purports to be an organic farmer. He doesn't sell genetically modified crops, and he said his crop was actually ruined by having this there. As I say, it's pretty clear the trial court didn't buy that, but it is a plausible scenario, even if it didn't actually happen to Mr. Schmeiser. Now, think about that in parallel with the situation we're going to hear more about in a minute, the so-called Sony rootkit. I won't go into great detail here because I think we'll hear more about it, but this is a digital rights management type of technology that was designed to prevent the unauthorized copying and trading of music. So when you put this particular type of music CD into your computer with this program, it would insert itself into the user's OS and actually created a security breach, acting sort of like a trapdoor or a Trojan horse type of program that would allow someone to actually infiltrate the computer that had been infiltrated with this program that was supposed to protect the music. May very well have happened without knowledge of the user because most consumers don't know a lot about how computers operate. And if the user was aware that it was there, fairly difficult to remove. And in the United States, and I think as we'll hear in some other countries, Canada and the European Union, potentially a breach of anti-circumvention measures to try to remove it. In the U.S., the act of circumventing an access control is prevented by our Digital Millennium Copyright Act. So if you think this is an access control, that would be prevented. And trafficking in technology that would allow someone to remove either an access control or a copy type control is also prohibited. So even if it is allowed for the consumer, if they know that it's there, to try and remove this, they would have to have the knowledge themselves. No one could help them to do that. Now, there's some interesting commonalities, I think, there with the Schmeiser analysis. A number of people have looked at Schmeiser and said, well, this seems sort of unfair that you could be infringing a patent without your knowledge, that a patented invention could be growing on your land, and you could be using it without knowing that it's there. Is there some sort of pushback, some sort of counterclaim that's available to an alleged infringer who's in this situation? A number of people, Paul Heald at Georgia, Stephen Munzer at UCLA, have tried to articulate possible counterclaims, things like, well, perhaps Mr. Schmeiser would have a claim for trespass, which in fact he did assert, or for nuisance, for having this seeds or pollen fall onto his land. That's an interesting idea, but of course, that really goes to the physical invasion of the property. It doesn't really deal with the intellectual property issues, with patent issues. Perhaps there's patent misuse there. or some sort of unclean hands by the patent owner? Well, perhaps, but again, this requires some sort of scienter typically, right? The patent owner has to have a nefarious purpose. It's not clear that the patent owner, Monsanto, had a nefarious purpose. It just seems that perhaps the pollen blew onto somebody's land. Could it perhaps be a weird form of contributory infringement, where the patent owner is supplying the infringer with the means to infringe the patent? Well, that seems strangely circular. So we don't have a really good way within patent law to deal with this problem. And there are parallels to the rootkit situation. Right? If the user attempts to remove the Trojan horse, the DRM program from the computer, which the user owns, that might be a DMCA violation. Are there any sort of counterclaims? Well, parallel to the trespass claim that you might have in the Schmeiser case, perhaps there's a trespass to chattels case. Right? We have a number of these situations where someone has put information or put a program on someone else's computer, and courts have allowed trespass to chattels claim. But again, that goes to the physical property. It doesn't really deal with the intellectual property. Is there perhaps some sort of weird bailment going on here? Because, of course, there is a modification of the software on the computer, but under our licensing regime, our shrink wrap regime, purportedly the owner of the computer doesn't own the software. It's still owned by Microsoft or Novell or whoever supplied them with the software. So perhaps they have some sort of derivative work claim, or perhaps they have some sort of claim for modification of the software, but it's not clear that the owner of the physical computer would, unless there's some sort of bailment that's created by having the software there. So we have a regime in which perhaps there's some pushback or some counterclaim by the owner of the computer on the basis of invasion of the physical property, but not much of an intellectual property claim. Somebody else would have that intellectual property claim. So I suggest that we're going to have more and more of these types of situations, sort of the parallel genetic DNA situation and Trojan horse rootkit situation, as we deal more and more with technology that, as my friend Pam Samuelson says, behaves. Right, things that are self-replicating. You don't know that the pollen has landed on your crops and fertilized it and created the claimed invention on your land. You don't necessarily know that the rootkit has invaded your operating system because it's programmed to do that automatically without the user knowing. When you combine that with strict liability regime in intellectual property, where you don't need any scienter to violate a copyright, to violate a patent, you end up with a situation that seems at least unfair and perhaps untenable. And physical property claims are available, but those at best could offset the infringement claim or the circumvention claim that might come up from the owner of the intellectual property. It's not really directed to IP. So taking a page from Michael Geist's colleague's book, I wonder if we don't really need to begin thinking in a different way about intellectual property, not just in terms of the rights, because our rights regimes here have a disconnect. They either don't address the intellectual property issue or they sort of stack the deck in favor of the intellectual property owner in a way that seems unfair. Perhaps we need to think about responsibilities, right? That if we're going to give you rights in intellectual property, if we're going to give you a patent in Roundup Ready canola, or we're going to give you some type of anti-circumvention protection for your DRM, that you also have some responsibilities not to invade, not to damage, not to create situations that consumers will have to deal with. That seems to sound a little bit like misuse or a little bit like unclean hands, but I think we need to, as I say, deal with it in situations where things are self-replicating. We may not have scienter. And so with that little sketch of my thoughts on the idea, I will turn it over to the next speaker.
Good morning, everyone. Yeah. How do I get it? Just take it full screen.
Let's try. Maybe it's protected.
Good morning. I think I'm representing more of the pro side of things, and the focus of my talk today is going to be on copyright law. Specifically, my name is Chelse, Ferrero, by the way. I'm from White & Case. I do a lot of intellectual property law, both patents and copyright, but I think for for TPMs and copy protection, I think it's really most interesting when you look at copyright law as an example. Copyright law gives content owners control over the copies of their content. And for the most part, copyright law sufficiently protects the rights of the content owner. However, in certain markets, protection under the copyright statutes alone is just simply not enough. And it's just completely impracticable. In industries such as software, music, and the movie industry, they face a particular problem. And that problem is that exact copies of their content can be electronically or digitally transmitted quickly and in large number over the internet. Now, under the copyright law, a content owner would have to track down every person who has a computer, every person that has access to the internet, and then sue them when they make an unauthorized copy of their content. No one has the time and the resources for this type of copyright enforcement. So, where TPM or copyright protection comes into play is it's a tool for content owners to maximize their IP rights. By developing alternative protection measures, companies have overwhelmingly succeeded without really any incident to protect their content. And for the most part, the market self-regulates these copy protection measures. Things like competition, product marketability, and consumer goodwill have really kept, for the most part, copy protection in line, and there really isn't a need for further government regulation in this area. What I would like to do, since I'm on the pro side of things, is I would like to give an excellent, I think, innovative example of what happens when copy protection is truly a success. And I would like to use as an example the DVD Copy Control Association, whom I do represent. DVD Copy Control Association, for those of you who don't know, control the copies of movie content on DVDs. What they do is they license what's called CSS technology, and it's made up of an industry consortium. It's just not the motion picture industry. What happened was, originally the technology to put content on DVDs was owned by or developed by Toshiba and Matsushita. They couldn't convince the motion picture industry to go with DVDs, so they put together a consortium. The consortium has not only the technology, but it also has content holders, which is the motion picture industry. It has computer companies, and it has consumer electronics companies. They made up this consortium, and together they licensed DVD technology. Now, I want to give you a little bit of the history of what went into all these major industry players putting together a consortium. In 1982, the compact disc, or the CD, entered the market. It replaced vinyl records and cassette tapes, and it was used to transfer music content. And it was a great and a huge technological innovation. However, a few years later, enter the personal computer, CD-ROM drive, and the internet, and the music industry completely lost control of its content. You could copy it, you could digitally disseminate it in large numbers. Everyone, I'm sure, is familiar with Napster. And the movie industry sat by and they watched this transpire. Mostly not because they were smart, but because the technology yet was not developed to put movies, which of much larger size, onto a disc. But when the technology did arise, the motion picture industry was very, very reluctant to enter this market. But in 1997, they came out with the DVD, and they put together this consortium. And what they did is they came up with a CSS license. CSS stands for Content Scramble System. What they do is the CSS is a standard-based protection system. It creates a set of requirements that everyone has to follow. It's a set of requirements for manufacturers of copy-protected DVDs or other playback DVD devices. They can become licensees, they pay a flat fee, and anyone can license the CSX technology. What CSX technology is, it's a bus encryption technology, and it also contains some regional playback for controlling geographic designations of CDs. And what it does is it has standardized the industry. Anyone who wants to enter the field can enter the field, and it's created a level playing field for all the manufacturers in the market. It's encouraged competition, and it's kept costs very low, because the replication or the manufacture of these DVD devices, by competition, it's driven down the price of these units, and it's really the value's been passed on to the consumers. And the manufacturers all have a vested right in keeping the terms of their contract and is still enforcing the rights of the content owners in their content. It's sort of a symbiotic relationship between all the industries, all the manufacturers, and then that has been passed down in a very positive way to the consumer. Let's see what else I've got. Anyway, it's this freedom of contract is what it is, coupled with copyright law and copyright ownership, that has really given this entire industry content protection, whereas copyright law alone, as the music industry really has exemplified, has been not enough. And I think I'm done.
Good morning. Oops, I didn't hurt anything there. My name is Paul Bawel. I'm in-house counsel for Microsoft Corporation. Much to Microsoft's chagrin, I don't use PowerPoint presentations very often. I'd like to just start off a little bit by explaining a little bit on the technical side about what DRM is. DRM is many things to many different people. If you have something you want to protect that DRM is appropriate to protect, it's basically a tool set that you pick and choose the pieces of protection you want to wrap around it. And it is just that. You take this object, it may be digital content, it may be access to a printer port, pick whatever you want. As long as you can communicate with it and talk to it and transfer information back and forth from it, you have the ability these days to control it and put rules in place about how it is used, who gets to use it, whatever you want to do. And that's really what we're talking about here. Such tools that are standard and what we generally know about for, say, digital content, a movie, a song, or whatever. And they do, I agree with Chelse, associate themselves very closely with copyright law. But such tools are encryption, obfuscation, authentication, authorization, watermarking, copy control. How many copies do you want to make? Do you always allow copies? Do you never allow copies? And other things such as emails, do you allow it to be forwarded? Do you not allow it to be forwarded? And so the DRM is a scheme based on your business model and how you want to allow people to use that thing you're trying to control. Generally speaking, it's about revenue. Sometimes it's about other things which are related to revenue indirectly. It's about privacy. And to some extent, that's what this discussion is about privacy. So let's talk a little bit about privacy, too. I mean, privacy is very important to all of us. Whether we're Microsoft and we sell solutions either individually for digital rights management to folks who have mostly content they want to protect. We sell solutions that are embedded in our own products, like the media player and like email or our Office platform. But generally speaking, privacy is important to all of us, and as lawyers, or many of us are lawyers or want to be lawyers in this room, we're very concerned with the privacy of our clients, and we have a lot of data that's very confidential to them. And we've learned very well how to protect that, and we go to hard extremes. But we've done it mostly with paper copies and very, very tight, now that we have access to the internet and stuff, tight controls to who can get in and out. And we put up a pretty hard wall, and that's a pretty simple solution. But in many businesses, a Verizon or anybody who keeps a database of all their customers' information, who've never thought about this before, this is a very alien concept to them. I myself moved from one state to another and closed down my phone account, and somebody had, with just my old phone number and my name, they'd gotten, I don't know if they got off a bill or off a database or whatever, they walked into this phone company's place and got a mobile phone. And I didn't know about it, even though I went to a new state, opened up an account with the same company. And I didn't know about it until the bill collector knocked on my door and said, we're going to start sending the sheriff after you. I said, for what? Nobody wants their information stolen, and I think we can all agree about that. But what I think we need to look at is the laws that surround that, and work on refining them and adding them in an appropriate way, and not just in a reactionary way. Because the laws always lag behind technology. And today we're moving at such an advanced pace that some of the laws that are put in place are having adverse and unintended effects that on more of a wide and broad scale are unintended, and maybe more dramatic than what the individual damage is from case to case. Of course, if it's you that's had the individual damage, it's pretty serious. But there are countries in Europe, and I think Belgium might be the most strict among them, where some of the requirements in the privacy laws are approaching strict liability. When we sell products, whether there are DRM products or any products that have to do with any kind of transfer of information that might be personal, we have to look very, very carefully at how those products work. Do they comply? Do they provide the proper notices? And do they allow the users to do the things that are required by the laws? And in some cases, and I won't say that this is Microsoft's case or not, but there are companies who choose not to do business or put certain products into those marketplaces. Who wins and who loses in those situations? And the other problems with information is it's not jurisdictional anymore. It's international. You can't just protect according to what you want to do here because somebody else will go grab it from another country, or it's almost impossible to say that the database of information you want to protect is only protected by your jurisdiction, because there's information from people all over the world. So we have to think very careful. We do have laws that in most cases are fairly sufficient. The problem, as Chelse said, is enforcement is very, very difficult. So what do? We create tools that work and get us to where we want to be. We're looking at really first generation. Look at where the internet is today, and look at where it was 10 years ago or even 20 years ago. And they're saying now we're on Web 2.0. I don't know that we're quite there yet. DRM and the tools we use to protect ourselves are still very early generation. But the barn door is open. The information is there, and it's sitting in these massive databases, and the only way for these companies to manage it is to have it there. The only way for them to provide us services is to have it there. Is it going to be painful for a while? Yeah. Will we ever get it figured out? I don't know. But I think we need to be very thoughtful in how we approach these issues and allow the intellectual property laws and the tools that are out there that support these rights to work in a way that get us. Because in the long run, especially if you believe in the free enterprise system, the marketplace generally figures out the best and the fastest, and legislation usually takes itself a longer time to work itself out. That's all my prepared statements. Thank you very much.
Good morning, everyone. Thanks to the organizers for the invitation. Given that this is a focus on cross-border issues, I'm the person across the border, talking a bit about the Canadian experience, but providing it actually as a bit of a case model for what's happening in a number of countries. Let me start by very quickly giving you some just 2-minute background on Canadian copyright law. We don't have anti-circumvention legislation, so no DMCA or nothing at all like the DMCA, at least not yet. We did sign the WIPO Internet Treaties, WCT and WPPT, and have spent the better part of the last decade debating whether or not we ought to implement it, and if we do, how to go about implementing it. I should also note that we have a very active Supreme Court with respect to copyright issues, and I think it's probably fair to say it's the most user-friendly Supreme Court probably in the world. A court that over the last few years has articulated a vision of balance in copyright where the rights of creators stand alongside in balance with the rights of users. So it's articulated a view that the exceptions that we find within copyright law are better thought of as user rights, and that those user rights ought to be treated in an equal fashion with creator rights. It's also noted that overprotection of copyright or IP more generally may be just as damaging as underprotection, and so has really sought to strike that balance. Now, as I say, we have spent some time debating how to go about dealing with the issue of anti-circumvention legislation within law, and we have faced, in a sense, the same kind of balance. The issue on the one side that, frankly, Canada and most other countries face isn't so much a question as to whether or not TPMs or DRM is a good thing. It's more about the pressure we face from the U.S. Trade Representative. Country after country, whether Australia, Singapore, Morocco, and others, have faced the prospect of negotiating trade agreements with the United States where a requirement of those trade agreements is the implementation of anti-circumvention legislation, often without some of the balance that one might find in under U.S. copyright law. And so in Canada, we already have a free trade agreement with the U.S., but nevertheless face significant pressure from the USTR. This year, we're the subject of a special review under the Section 301 review, where the USTR tells most countries that their IP protection isn't up to the standard they would like it, and the expectation is that that review will tell us that we aren't doing what the USTR would like us to do. And so that faces, for a country like Canada, where the majority of our trade is with the United States, that's a pretty significant pressure in terms of how we might move. Faced off against that is a view that there have been incidents, with all due respect, with respect to what's happened with the DMCA, whether the Sony rootkit case, the Skylarov case, the issues that Professor Ed Felton at Princeton has faced, cases involving Streambox, which had implications for the use of fair use and how it may be trumped by anti-circumvention, the Lexmark case for printer cartridges, the Chamberlain case and Skylink case, which is actually a Canadian company involving garage door openers. I think the prevailing view amongst many in Canada has been that there are many incidents to draw from the U.S. experience with anti-circumvention, which may give people some pause. Now, a year or so ago, we actually had our first bill introduced that sought to implement anti-circumvention legislation. It actually failed when the government fell, but it is somewhat instructive in terms of a different approach with respect to implementing these kinds of provisions, one that is being followed by a number of other countries. New Zealand recently introduced anti-circumvention legislation that is somewhat modeled after what we were trying to do in Canada. There are two main points I would want to highlight. One is we had no provisions with respect to devices. The notion of banning devices that can be used to circumvent was simply seen as unnecessary and highly inappropriate, given that there may be many instances that those technologies have perfectly appropriate uses, and to make access to those technologies or distribution of those technologies blanket illegal created some real problems. The other thing that we did was seek to draw a direct link between circumvention and copyright infringement, and so that it would only become an infringement where someone circumvented for the purposes of copyright infringement. Circumventing for other purposes, for lawful purposes, would still be permitted. The approach there was really designed to do away with the exception-based approach to anti-circumvention legislation that you have here. As you know, There is the triennial review of the potential for exceptions under the DMCA. The view here was if we could ensure that the various exceptions or user rights were retained within our law, we would do away with some of those challenges. So if you were to circumvent for fair use or fair dealing purposes as under Canadian copyright, as exists under Canadian copyright law, that would be permitted. If you were to circumvent to protect your privacy, that too would be permitted. So the range of reasons that someone might want to circumvent a TPM, and there are many legitimate reasons for doing so, would be protected by drawing that direct link between copyright infringement and the purpose of the circumvention itself. It's also worth noting that we've had some other legislation recently introduced that touches, in a sense, on TPMs. Just a few weeks ago, we had new laws that took effect with respect to our library deposit regulations. So library deposit you have in this country as well, the requirement that all publishers submit copies, 1 or 2 copies, of their work so that we maintain an archive, a historical archive of everything published within your country. And many countries have this. Under new Canadian law, publishers that use DRM for electronic books that would be otherwise subject to legal deposit are required to strip out that DRM as well as provide keys and access points to our national library. That's because there is deep concern, and I think it is quite legitimate, that the prospect that future generations might well be locked out of content as it is locked down by these technologies, I think is a real one. And so the Canadian government's taken the approach of saying, in order to appropriately preserve access to our heritage, we're going to ensure that there is no DRM as part of the depository program. Now, I'll conclude by noting what is the effect of all this. And of course, if one were to listen to the advocates for DRM, you'd think that, well, we must surely have no services that would make use of DRM because we don't have anti-circumvention legislation after all. We must be a nation of pirates. The truth of the matter is that we have access to all sorts of online legal services. We have iTunes, we have Rhapsody-type services, we have movie services that offer downloads. And last year, according to the numbers that were released just a week or so ago by Nielsen SoundScan, the growth of that market grew in Canada at 122%. By comparison, the U.S. market grew last year at 65%. The European Union grew at 80%. So we actually led the world last year in the growth of this marketplace without anti-circumvention legislation. We are admittedly starting from a lower base, but that's because people arrived at the market 2 years after they did in the United States. Notably, in Canada, we've had a number of groups emerge over the last year or two that have been very focused on these issues, on, I suppose, what they would describe as the incidents that they've seen elsewhere. For example, we've had the Canadian Music Creators Coalition, the CMCC, representing some of the best-known Canadian artists, Avril Lavigne and Bare Naked Ladies and Sarah McLachlan and the like. It's actually pretty much a who's who of some of Canada's best-known musicians. They stepped forward last April to say both that when the recording industry sues their fans, they don't do so in their name, and they advocated that the labels stop taking that approach. Moreover, they argued against DRM. They believe that it has a negative impact on their ability both to connect with their fans and the ability for them to ultimately sell music. From a privacy perspective, I'm glad you raised that. We had 4 privacy commissioners, our National Privacy Commissioner and privacy commissioners from 3 of our largest provinces, Ontario, British Columbia, and Alberta, all signed public letters to the government expressing deep concern about the privacy implications of anti-circumvention legislation and request that a full privacy impact assessment be conducted before any such legislation would be introduced, and that there be appropriate protections for privacy within the context of anti-circumvention legislation. We had our Documentary Filmmakers Association, which includes a number of Oscar winners, step forward just in December to express the view that copyright was hindering their ability to engage in their craft, and that expressing concern about what anti-circumvention legislation would mean for them. And we have had Canada's leading security research companies take a look at what occurred to companies like Elcomsoft, where they have their software programmer spend a summer in jail for disclosing some of the work that they were engaged in, and say that Canada might well enjoy a competitive advantage if we avoid the mistakes, in their view, that have occurred elsewhere. So we've had some I think, interesting developments that provide a case study for where we're going. Ultimately, I must admit, though, I am somewhat pessimistic, because that is the one side of the balance, and the other side of the balance is that pressure that we face, not just from lobby groups in the United States, but I think more importantly from our major trading partners. And so people will be looking in Canada certainly with interest to see how this plays out. But it's one jurisdiction that I think almost has a last mover advantage, in the sense that we've had the opportunity to see how this has played out elsewhere, and have sought to strike a bit more of a balance with respect to how we deal with TPMs and legal tools that protect those technologies. Thanks for your attention.
I'd first like to thank the law school and everybody involved in having the forum today. This has been very informative. I'm sure we're looking forward to the rest of the speakers. Copyright holders have long attempted to prevent unauthorized copying. In software, my first experience with that was with the game King's Quest III. King's Quest III required you to look up information in the manual in order to play the game. The previous versions had special software that caused some obfuscation of the way it was stored on floppy disks. Later, different companies also adopted this manual-based copy protection technology. One of the most notable ones would be SimCity, which used a red piece of paper with black print that was almost impossible to copy. You could freely copy the software, but you couldn't use it because you couldn't have the red sheet. Of course, when your mother threw it away, you were out of luck. But this is not... The same year that King's Quest was released, in 1986, two brothers from Pakistan created the computer virus Brain. The computer virus Brain was actually not designed to be a malicious piece of software. It was created to protect their software. The two brothers from Pakistan wrote medical software, and their medical software was being copied at different clinics. So they installed a virus that when you made copies of their software would put itself on the other floppy disk that you would use in your computer at that time. This exploded and became a very widespread infection in the United States. And caused a number of problems. But as you can see, this is actually the message that you would see when you were infected with Brain. It even included the phone number of the people who had infected your computer, asking you to call them and obviously get it removed, and preferably buy a license from it. Such misguided attempts at copyright protection continue to this day. One noticeable example is the 2005 Sony BMG XCP and MediaMax copy protection controversy. This was kind of blown open by Mark Rusinovich on Halloween of 2005. I actually had my computer infected by one of the CDs that I purchased. This software was intended to be a presentation software. It would allow you to play the music and allow you to make copies of the CDs, a limited number of copies, and allow you to put the media files, which were pre-encoded, so you didn't have to run them through LAME and make your own and copy. You didn't have to put it in iTunes to get it into your machine. It was going to already be on the CD. Well, in addition to doing that, the software also stored itself in a rootkit. It installed software that surreptitiously would monitor the actions on your computer. It would phone home to Sony at certain times whenever a CD was reinserted. And it did this without full notice to the user of what was going to occur on their computer. In fact, some of the software that was used by Sony, it presented an end-user license agreement when the CD was inserted, but when the user selected that they did not wish to abide by the terms of the agreement, they did not wish to install the software, it installed itself anyway. There are two different variants that were released. The latter one I just spoke of was called MediaMax. Based on an examination of computer name servers, the phone home method of the XCP software required it to access a server at Sony. There was no other reason to access that server other than that your computer was infected with XCP. by investigating the internet name servers, the servers that your computer uses to convert the text you type for domain.com into an IP address, it was able to be determined that over 568,200 networks worldwide were infected with at least one copy of XCP or MediaMax in 2005. This map here shows some of the extent of that infection. At its peak, the infection was strongest in the United States and in Japan, but infections were seen in at least 162 other countries, and the infection existed on commercial, educational, and even military networks. This is a copy of what the software would look like on your computer, what you saw and what you were exposed to by Sony. It was a media player, had a small advertising section, allowed you to play the music. You were also allowed to burn copies of the disc and to copy DRM files to your machine for portable to music players. Of course, it didn't work with the Apple iPod because Apple doesn't let anybody use its DRM. I'm certain that you might have some more interest in this subject. There are a number of resources. Wikipedia has some very good articles, as well as my website, sonysuit.com. And I've also included on your CD with your packet there most of the important pleadings from the Sony BMG class action that took place last year to help you provide you some more background information on that. Of note to us is the need for the XCP and MediaMax writers to create a part of their software that remained hidden from the users. In order to accomplish this, Sony BMG resorted to methods that would be quite familiar to our Pakistani brothers. They created a computer virus that hooked in the operating system at such a low level that the files beginning with a specific prefix would not be visible to the user. Once this hiding method was established on a sizable number of computers, malicious programmers exploited it as a way to hide their viruses and spyware from the user and from the user's antivirus programs. The removal process, this is even more fun, that was released by Sony BMG after a public outcry reached a level that they had to respond, even went so far as to create a new round of vulnerabilities in your computer, and these were accessible over the web. These vulnerabilities would allow people to remotely install software on your computer or to reboot your computer at will. Sony BMG had one thing going for them that our Pakistani brothers would not. They had, because of their size, the trust of the antivirus vendors. There were a number of reasons given by the antivirus vendors for not detecting and removing this rootkit, but one of the primary ones is the DMCA. As understood by the antivirus vendors, the DMCA prevented them from doing anything about Sony BMG's technical protection measures. Because they risked the penalties of the DMCA if they circumvented or assisted their users in circumventing the Sony BMG TPM, they chose simply to do nothing. Recently, the Copyright Office has eliminated this excuse by allowing as one of its newest exceptions to the DMCA, the exception for sound recordings. This is such a tightly drawn exception that allows circumvention, but it does directly cover the situation caused by the Sony BMG incident. As a result, antivirus vendors should carefully begin examining all TPMs for any vulnerabilities, mostly that will be unintentional, that will be created by the installation of the software, so they can protect their customers. The actions of Sony BMG were certainly civil wrongs, but they also violated a number of criminal statutes in some states. Sony BMG has not been criminally prosecuted, nor have any of the programmers, but they have paid a large sum of money and have replaced a lot of CDs for releasing the software to public, but generally, the company has moved forward unharmed. The risk to Sony BMG or another large entity accidentally creating security holes through which the installation of their TPM is one which still exists. If TPMs continue to be utilized, which in the near term I certainly expect them to be, I submit that several things be required of those who wish to install them. First, the presence of the TPM should be fully and accurately communicated to the customer. The communication by the TPM with any remote system should be explicitly authorized, and preferably that authorization should come at the time that the communication is going to occur. Information that's gathered by the TPM should not be retained for any period longer than necessary. One of the problems with the Sony situation is that they were logging your IP address information based on the CDs that you inserted. They could understand your listening habits and use that information for their commercial benefit or your personal harm if they so desired. The TPM must be capable of being fully and completely removed at will by the customer. Sony's DRM was unable to be removed by most users, including myself, and I'm a former computer programmer. I spent a lot of time trying to get it out and couldn't because it hooked itself into the CD-ROM drivers that when you actually got it removed, your CD-ROM no longer worked. The TPM must be capable of allowing fair use. There are exceptions in U.S. copyright law that we need to provide the exception for, even while protecting the content. And all the code associated with the TPM must be verified and publicly authenticated by at least one independent licensing body, so that we have an independent pair of eyes who can look at the software and ensure that it's going to be safe and comfortable for use on our computers. I certainly hope that entities that would wish to utilize TPMs would look at the alternatives of allowing their customers free use of their software. Not free as in access to it without pay, but free as in the ability to use the software or the content without the restrictions imposed by a TPM. Watermarking and other methods are available to combat the threat of piracy without the need to take control of every user's computer or to limit our innovation. Thank you.
Okay, terrific. We've had a relatively unprecedented scenario where the speakers all kept to their scheduled time. That has preserved opportunity for us to have a little bit of discussion about the topic.
We're afraid of you, Eric.
I'm sorry?
We're afraid of you.
I did mention something about breaking kneecaps. That obviously had its deterrent effect. So I have some questions I could field to the speakers, but before I chime in, let me throw it open to the audience. What would you like to discuss amongst yourselves or with the speakers? Questions or comments? Yeah, Tyler.
Let me start with Mr. Lyon and ask him, what are you suing Sony for? And is it a class action? And what are your causes of action here?
I did not file a class action. I actually wound up being sucked into the class action as it grew. There was an order entered that actually moved my case and many others into it. I filed in state court for a number of issues relating to our state computer crime laws, to our privacy violations, and to the unlawful use of my computer.
Do you want to add the status of it? Because
I can't fully go into the detail of my case, but if you'd like to look at the complaint, it's available to you at sonysuit.com.
Okay. Yeah. Phil.
I had a question for you. In the Monsanto case you mentioned, it has a lot of aspects of but as far as TPM, could you go into the Terminator gene and how that would be affected, and also how any recent legislation might be encouraging the Terminator gene for farmers under the conditions that give them the right to plant seeds after.
Sure, this is good stuff, and I've written quite a bit on this. The Canadian case, the Schmeiser case, actually doesn't have a lot of contract issues in it because Schmeiser got the seed from somewhere else, and alleges at least that he never would be subject to the seed wrap license on the bag. We have a number of cases in the U.S., however, including the McFarland case that was just re-argued in the Federal Circuit by Mark Limley, who's around here somewhere, a couple of weeks ago. That do involve the so-called seed wrap. The Terminator or GERTS, genetic use restriction technology, is of great interest to me. It doesn't really show up in the Monsanto versus Schmeiser case, but it is effectively, for those of you who haven't followed this, the biological equivalent of DRM. It's the ability to build into a seed a genetic program that prevents the seed from reproducing in the next generation, even involving, in some very sophisticated versions, a chemical password, where you can supply the farmer with a proprietary chemical that will allow them to unlock the seed and grow it in a succeeding generation. We don't have a biological equivalent to the DMCA. We don't have anti-circumvention protection for biological DRM, so to speak. But at least at the moment, patent law would serve a very similar purpose, I've argued, because the Terminator technology or the GERTS technology is patented, and attempting to circumvent it might very well be using and otherwise infringing on the on the claimed invention. So at least for the moment, patent law may be playing a parallel role to anti-circumvention legislation. And after that, things become very complex very quickly, as you indicated. One, because there is a licensing regime associated with that. So whereas in software and digital content, we think about copyright being associated with the licensing and with the DRM, but in the biological sphere, it would be patent being associated with the licensing and with the GERTS, the genetic use restriction technology. And there's a parallel form of intellectual property, plant variety protection, that actually specifically allows farmers to save seed from year to year. That seems to be being overridden by either the license or by the GERTS if it's deployed. So you may have a parallel situation to what a couple of the speakers have talked about with fair use. In digital content occurring in the biological sphere, in the patent sphere, but there it would be the farmer's right to save seed that would be overridden by the DRM, by the biological DRM, rather than fair use. And I can provide some citations to things people have written on this, including myself, that goes into that in more detail. But that's sort of the picture in a nutshell.
So does the use of the terminator gene in some of these seeds then classified? I know that farmers were up in arms because it didn't allow them to save the seed, so they were interested in, like more of a public outcry against the use of the seed.
Yeah. At the moment, Monsanto has chosen not to deploy the technology because of the bad public relations that you've mentioned. And in fact, the last meeting of the signatories to the Convention on Biological Diversity, which doesn't include the U.S., we never signed on to the treaty, but the majority of nations, particularly developing nations that have signed on to it, met and agreed unanimously not to allow testing or use of the technology in their borders. So the U.S. is one of the very few places in the world where it could potentially be deployed. It hasn't been deployed yet, but Monsanto continues to take out patents. So we know that they're still very interested in the technology, even though they haven't actually deployed it yet, and that's as a result of this outcry that you mentioned.
It seems like they did incorporate that gene in some of these plants that actually serve to benefit others who are using data. It wouldn't allow genetic engineering plants to reproduce on their own, as you mentioned, that have concerns of cross-field contamination, which has been shown off.
Yeah, the concern the number of people have raised in that area is that they're concerned that the DRM itself, that the GERTS itself, might propagate to non-genetically modified species. So the prospect that you have is having that trait then appear in plants where it wasn't intended to appear, and there's some possibility that could happen.
Other questions or comments? Yes, sir.
To the DRM technologies and so forth, it seems like in copyright law there's always importation and the requirement to put protections and mechanisms in place to protect copyrighted material. But yet there's no requirement as there is in patent law for any sort of novel convenience or utility. Is it possible, and it seems to be probable, that maybe the law as written is a little too loose and less shoddy protections out on the marketplace that really aren't effective protecting the copyrighted material? And so how could we change so that there is a higher standard for technology that's going out to protect copyrighted material?
That's an interesting comment for a couple of reasons. My friend Peter Swire at Ohio State has made precisely that argument, that because our DMCA is so broad, it covers effective, quote-unquote, technical protections, which means essentially any process where you apply information. That your Captain Midnight decoder ring from the box of cereal is potentially something that could fall into the DMCA. But the bottom line being that it encourages lousy TPMs. That you would get better TPMs if you had more targeted protection. The other part of your question is interesting because this hasn't really been faced squarely. A couple of courts have dodged the issue. But because the DMCA protects so broadly, including potentially material that is not original under Feist and material that is not non-obvious under Graham versus John Deere, there's a real question as to whether it's constitutional or not. And a couple of courts have ducked that question. Some of us filed an amicus brief in a couple of cases, and courts kind of said, well, we don't want to deal with these funny law professor arguments about constitutionality. But that question is still floating out there. The Federal Circuit may have dealt with the problem by doing what the Canadians want to do directly, by connecting copying to circumvention. In the Chamberlain decision specifically, saying, if you're not copying, it doesn't implicate the DMCA. And if that's the case, then it may well be that it's now back within the purview of constitutionality. But if you read it broadly, if you read the statute on its face, you may have put your finger on a constitutional defect.
Just to highlight a different constitutional angle, one we face in Canada, it's actually my colleague Jeremy DeBeer, who Dan raised earlier, has written about this issue. And that is, under Canadian law, copyright is a matter for the federal government, but property and civil rights fall to the provinces. And the question becomes whether or not any circumvention legislation is really copyright legislation, or rather regulation of personal property. And the further away you get from copying, the further away you get from this being something about copyright. It's really para-copyright, as it's often described, and thus subject to a constitutional challenge. And so there are those that argued that the approach we took with the direct link to copyright for the purpose of copyright was actually a constitutional necessity, because if we were to have something that was so broad, as I think the DMCA is so broad in this regard, that might well be unconstitutional, because the federal government, our federal government, wouldn't have jurisdiction to legislate in the area.
Anyone else on this question?
I'd just like that. Let's remember, it's really easy to sit in a room like this, and we all went through law school, and with all due respect to the professors and the people who practice in that very esteemed positions and profession, realities are that there's only a certain amount of content that's valuable enough that people want to go out and copy it, whether it's seed genes or whether it's music. There's only things that are what people want to copy. And amongst those people who create that, there's a great diversity of how they want it copied or not copied. And the biggest issue that we have to remember is, once there's a digital copy out there and it's floating around, it's out there. And every copy you make is still the original. And those people who want their content or whatever it might be protected have that right, because we all, I think, agree that the copyright before DCMA and digital copies, copyright as it existed, whether we agree with the term or not, protected those things that we thought ought to be protected because they bring value to us as a public policy reason. They bring us art, they bring us technology advances, they bring us all those things that created the law in the first place. What we're in a transition period. And what I said before, it's not that we don't need laws. It's not that our laws are where they should be, and it's not that we shouldn't strive to continue to fix them. But we can't. I think we're past the age where one size fits all, and that's the problem. And it starts to get so complex that there are no clean answers until the law starts to catch up. The problem is, by that time, in today's world, technology is already 3 steps ahead. So how do we deal with this? And I'm not proposing an answer, except to say where these things jump ahead. Generally the law you have in place at least has some remedy, and the marketplace does generally provide the quickest and most appropriate solutions for that immediate time and issue, such as Mark here, who took his case to court. Will everybody do that? No. But by the time the laws catch up and prevent companies from doing what happened there, assuming it was wrong, I won't make any judgment calls there. Let's just say assuming it was, and then we're too late. So it's a great academic exercise, again, with all due respect. But the reality is by the time we solve these problems, we'll be on to something else. And that's where, companies, not just Microsoft, lots of companies are out there to provide the tools for companies to build these things. We don't tell them how to use it. We aren't required to police its use, which That's a scary thought. I've been involved in another case in another issue in the cable industry where Adelphia Cable and the Regises built their company for billions of dollars. When they came to us, the authorities said, why didn't you go out and find out what they were doing with all this money we're paying them? Well, think of the not that that's directly applicable to this situation, but when we have to start taking steps like that to just sell the tools, think of the chilling effect that has. If you have to go out and make sure that all your business partners are following the law, that's never been one of the requirements. And we have to be careful of those kinds of legal structures, because at some point in time, if we aren't careful, the legal structure inhibits the business structures and our economy suffer, as do the arts.
Let's have Chelse chime in before we...
I want to chime in really, really quick, because lest we all forget, the DMCA was fully legislated. The Copyright Office put in its 2 cents. A lot of it was ignored, and Congress intentionally drafted it to be very broad and to let the market and the judiciary create further rules and regulations.
You guys decide amongst yourself who wants to take a crack next.
Yeah, I want to agree with Paul's comment. I'm not sure it plays out the way that he suggests. The DMCA, and I was very involved in the drafting process, which was completely co-opted by the content industries, was an attempt to get out ahead of the market and out ahead of the technology. That's the reason it's a complete disaster. And most of the comments that we're making in terms of fixing the problem is fixing an attempt to legislate ahead of the technology and ahead of the marketplace. So I agree with the comment. The DMCA is the poster child for why you shouldn't do that. And the discussion we're going to have in this panel and the discussions we're having ongoing is an attempt to fix what happens when you try and do what he suggests you shouldn't do.
I just want to note that I think it's always important to distinguish between the tools and legal protection for the tools. When you say you want to sell your solutions to people, I haven't heard a lot of people say that you ought not be allowed to do that. I think we have heard that there are implications from the use sometimes of those tools, and that we ought to be entertaining the prospect of certain kinds of protections against misuse of those tools. But what we're talking about isn't whether or not you can make use of TPMs. What we're talking about is whether you need, in addition, legal protection for those TPMs. And I think when Dan says it was getting out ahead, the truth is you didn't let the people who advocated for this didn't let the market decide. Frankly, the market is deciding right now, and it's making pretty clear that consumers don't want this stuff, which is why the content industry is abandoning TPMs by and large, because not only do they not work, but consumers don't want them, and so then you can't sell your products. But this isn't about the market. This was about putting legal controls on the market. I think many people would have been very happy if we would have just let the market decide. We wouldn't be talking about the DMCA, and frankly, we wouldn't be talking about abusive uses of TPMs because the market would dictate that you wouldn't put it into effect in that fashion.
At the end of the day, you've got to remember that you've got a paying customer who's taking your product, who's going to be buying it, and also hopefully buying it from you in the future. So it's very important that you make certain that the steps that you take to protect your content, first, that they're effective, but that they don't impose such an obligation upon the consumer that they choose no longer to buy your product. One way, education and the other efforts that the DVD Association has been involved in have been very effective in helping consumers understand the value of the content that they purchase and to help them understand the rights that they have and the ability to use it. So it's important that those education efforts continue as well.
Well, and I just want to say, remember, your customers are paying. That's the key word, is paying. It's shown that, the consumer, if they have a choice, doesn't want to pay for it. And that's the problem. They're, in a sense, stealing from the content owner, and it totally undermines copyright law in its essence.
Sorry, but that's just simply not the case. I mean, I challenge you to show me any evidence that consumers on a whole are out there just simply trying to get it for free. There's no shortage of evidence, frankly, to suggest that peer-to-peer has an impact on the recording industry is greatly exaggerated, and that the impact on the recording industry is far more attributable to things such as retail channel issues with respect to Walmart becoming the largest player, and frankly competition from your members. DVDs weren't even a consumer product at the time of Napster. So there's lots of reasons for this. To suggest that everybody's out there to take this And so that's when we have to lock it down. I don't think simply accords with any kind of reality that we're seeing in the market today.
I completely disagree. The music industry has been hit so hard by illicit copying, I don't even think it can recover. I mean, it has been hit that hard. I mean, to say there's no evidence, I mean, look at their balance sheets. There's evidence. I mean, they have
don't
other
disagree there.
related
I don't
issues,
disagree.
and I'm not saying it's completely confined to this single issue why the music industry has been suffering, but definitely digital music it's been a tremendous blow to the music industry.
No one has shown that connection.
Well, and the only thing I'll add, and I know we have other questions and lots of disagreement on this, is I think, and just because I'm required to do this and I've forgotten to do this so far, is my comments are mine personally, not Microsoft's. Thank you very much. But I will tell you that I agree that there are channel distribution problems that are serious issues that the industry needs to address. I will also tell you, as the father of teenage sons who have lots of kids out there that are their friends and who walk around with their iPods and who have literally thousands of songs in their computers, that, I stopped trying, being an intellectual property attorney, and say, look, you can get dad in trouble, maybe, blah, 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 blah. That worked for about 2 years. And I probably paid for, $300 or $400 worth of songs. And there are thousands and thousands and thousands of songs on these kids' computers, and they share them freely. So and those are the people who buy most of the music that make the money for the recording industry. So there is some of both. And to say there's no evidence, I think, is saying that people aren't looking in the right place, and they're trying to create their side of the story. But to say that it's all theft is not actually true either.
I think Paul also meant to say that the remarks that he makes here should not be attributed to him in a court of law as well.
Thank you very much. What did I say?
I want to chime in on this one. I'm trying to remain the neutral moderator, but I do think we need to make some distinctions here. We have been focusing a little bit on regulating consumer behavior, and technology can regulate consumer behavior. DRM acts as in some cases an effective, in some cases an ineffective measure to do that. Whether we needed legal protection to bolster the technological regulation of consumer behavior, I think is, in my opinion, an open question. I have my instinct to think that it was unnecessary, but that's probably a biased statement. My bigger problem with the DMCA as a regulator of behavior is its anti-competitive effects. The fact that it has been leaching into otherwise healthy market processes and restricting competitors trying to engage in what might otherwise have been viewed as lawful competition. From that perspective, that's where I see the DMCA's real failing. So when we talk about trying to regulate consumer behavior, we should recognize that the collateral consequence may be we are actually hurting consumers and competition in a different market. Sorry for the advocacy statement from the moderator. I see a bunch of other questions. Let's start with Michael.
First I'll give my 2 cents on the constitutionality question. I think there's an easy case to be in Congress, but as a whole.
Gibbons versus Railway.
Okay, so following up on what Eric just said, I guess a lot of what's been said is really the tension with respect to fair use between those who think that there should be digital rights management and those who don't. Some fall on the side of, well, it's our stuff, we'll lock it down as much as we want, too bad if we want fair use. The other side says, well, it hurts competition, we don't have fair use, it makes it hard to make documentaries. And so I guess the question I have is there any principled way to figure out which side of the fair use, who should get the initial rights, essentially, given that you're not always going to have transactions? Is it just an empirical question? Is there a philosophical question in there? And I guess given the subject of this conference, how does that affect cross-border? For example, if you go to Canada, you extract what you need for your documentary, and you ship it back to the U.S. where you haven't done an illegal anti-circumvention, but now you've got fair use, and so everything's okay. How should we be allocating those rights, and what are some of the complications of multinational, digital things are easy to copy, and things are easy to copy internationally as well?
Well, let me explain my one-liner, and then we'll turn it over to Michael and others to talk about the trans-border question. We have Supreme Court precedent that says you cannot use the Commerce Clause to make an end run around a limitation in another enumerated power. And we know what the limitations are on the Copyright and Patent Clause. Things have to be original or they have to be non-obvious. So the implication of Gibbons is you can't use the Commerce Clause to make an end run around that.
Yeah, I would think that.
Well, I mean, with respect to cross-border and fair use and the like, I think there is a huge challenge. I don't think it's so easy to pick up in one jurisdiction, get what you need, so to speak, and then go run to the other jurisdiction and make use of it. You run into problems all the time. Sort of a classic case where that comes up is in the context of public domain works. So we haven't extended the term of copyright. We're still at life plus 50, and hopefully going to stay there. And so you could get certain works that are public domain in Canada, but just because you acquired them sort of in Canada under the public domain doesn't mean you then get to come to the United States and make use of them in certain ways, because they may not be public domain when you come back to the United States. So I think cross-border creates some real complications, which is likely why the USTR, one reason why the USTR, as I was describing, has been as aggressive as it has been on some of these issues with other countries. I mean, from their perspective, a harmonization, or perhaps more accurately described as an Americanization of copyright law on a global level, certainly has certainly some benefits for U.S. entities in particular that might want to ensure that their content or their copyrights are subject to a similar sort of regime on a global basis. On the other side, you've got other countries, of course, as I've articulated, that are not so comfortable with that approach.
And just let's remember that copyright law, where it's been extended, was extended primarily because of things that were also protected under trademarks. And we can debate whether the extension in the copyright law was really necessary or not.
And also, like, the Recordings Act of 1995, in effect, adopted an international treaty, but legislation kind of took the teeth out of it. So, like, royalty payments for music from international countries. I guess the intent was there, but the payment isn't there. I mean, you can play songs, you can play content in Europe, and really don't have to pay royalties still into the content owners in the United States.
I think one of the things that you can see, the spread of the corporate view that we have here in the United States on our intellectual property, spreading to other countries through our trade representatives and through other negotiations, would be to look at the allofmp3.com situation that's going on now. Allofmp3.com is a Russian service that offers music downloads for pay, but without DRM. I used to be a heavy purchaser of music CDs. I'm from Jackson, Mississippi. We have a local record shop. I would spend $30 or $40 there every month. I quit buying music CDs after I had my infection with Sony's XCP and began buying music online. And instead of buying from the iTunes store, where I have to worry about, is this going to work on my Zune when I buy it? No. Well, am I going to have to buy it again? I look towards where can I get music for pay, where I'm providing money that goes back in some way to the people who helped create it, but also provide me with the convenience and satisfaction that I'm looking for as well. And, for me, that was to go to an international country and buy from the Russian mob.
I think Mark also meant to say that his remarks should be not attributed to him in a court of law. Last question.
You also touched on the issue of pay, and that also raises, particular implication of the DRM use. Again, that is what business model we're going to use with the TPM. And, there's no problem with having paying customers. The problem is when you try to construct a business model upon the concept of making the customer pay more than once at the same time. So, ideally, in Sony's world, obviously, we use TPM to isolate, discrete copies of the content, so that when you download them on iTunes or what have you, I have to download it, once in my iPod, once in my, DVD player, or the DVD, or what have you, and essentially pay multiple times for the same content. Now, my question to the panel is, with that in mind, first, do you think that business model is a viable one, both being pragmatic and second, do you think that's really a proper role for TPM, regardless of whether or not it's
we keep dragging Jeremy DeBeer into this. We both probably should have invited him to the panel, but Michael's colleague has a great paper that's up on the SSRN site right now on the Canadian experience, contrasting levies, the royalty model to TPMs, and that actually is generalizable. Julie Cohen and I are working on some work in this area as well, looking at the European Union model. TPM, as Michael said earlier, clearly doesn't work. There's no example of it working. It annoys consumers. The real alternative model, as you touched on, is the levy model. And actually, I'm sort of in disagreement with Chelse again. I think it's backwards from what she suggested. The U.S. is out of sync with the rest of the world. We're the ones who haven't figured out the levy system. We're the ones who aren't in compliance under WTO rulings with regard to levies. And the rest of the world is figuring out that levies actually work, whereas we're still stuck with this goofy TPM thing. I think eventually we'll see the light and adopt that business model, but it may take us a while.
Just to defend myself a little bit, I don't think that the levy system doesn't work. I actually think it does work. I just think, as far as bulk industry is gone, I think they came to the table late with it, and I think it is changing the market, and it's definitely the way to go. But I do think there's a time and place for TPM, and you brought up iTunes, which is really interesting because, it's a proprietary method. It only works with Apple products. And that's always the way Apple has gone. Microsoft is a good example of you buy Windows software and you have to register with the server, and it's really been effective way to control copies of their software, and you can it's easily accessible to get further licenses for the same software, I believe. And it's just two different ways, two different approaches, and I think as with Apple did originally, whether it's a successful business plan, time will tell.
Well, and the only thing I'd like to add is I'll disagree that there aren't successful technology protection models out there. They're very successful to people who, again, don't want to pay. The cable industry, for example, is very successful with protecting HBO and Cinemax and their pay-per-views. But let's remember, the ones that are out there that work are closed proprietary systems. The ones that we're just really discussing here are the systems that are open and available across multiple platforms that the internet as a tool has provided us the ability to come upon. It took us a long time to get from steam engines to automobile engines like we have them now, nuclear power plants. A lot of people still think we don't have that worked out. What does that mean? I don't want to sound pessimistic or sarcastic, but I think that if we think we're solving this by thinking it out this way, all I can tell you is as soon as we come up with a solution, the smart folks out there who love to just make a name for themselves because they say, oh, I did hack into that, I don't care that I didn't make any money, I just wanted to prove I could do it, they'll figure out a way to get around it. CCS, what protects DVDs, was out all of about 6 months before the first hack came on the market. Vista's been out, and we already have people breaking into it. Is it much more secure than it was? Absolutely. But these things are holistic plans. The authentication and call-in registration that we have for Vista is very effective in countries with effective laws. It still isn't very effective in China, because people figure out a way to get a copy and then it propagates. So, again, we need to think academically, and you can't get to the next place without doing that. But we need to think about holistically. And the last thing I'll say is I think there are solutions out there, but I think the two sides, the ones who say no copy protection, or we always have to protect these kinds of rights, and we always have to make sure fair use is done, and then the other side who says we always have to protect the content, aren't yet willing to sit down and talk about it. I've been involved in companies to build these solutions for a long time, and what I can tell you is the things that we propose as business solutions, one side always picks something they don't like, and says, oh, we just won't even talk about it anymore because we just will not agree to that. End of story.
All right, well, with that, what I'd like to do is call this panel to a close. I want to thank the panelists for their contributions as well as the audience. Thank you very much. We are going to take a 10-minute break, and we will reconvene at 10:15 with the next panel. Thank you very much.